All advice given is for general information purposes. All legal cases are different, and you should seek the advice of your own attorney before acting or making decisions. No attorney-client privilege applies to communications on this show, and no attorney-client relationship is created by calling or writing in. Attorney Rominger practices only in Pennsylvania and maintains his primary office in Carlisle, Pennsylvania.
All right, Carl Rominger here, 540-0580. Good Saturday afternoon. Steph, go ahead and call in. I don't know why Shane wouldn't put you on hold. I don't know what his problem is over there. I apologize. See, I get Facebooked and called at the same time, so I know everything that's going on. Keeping eyes on everything. Anyhow, call 540-0580. We'll get your legal questions answered here. For those of you who want to go to my Facebook page, you can check out my exciting race from this morning. I went and ran a 5K at the Dickinson School of Law. They call it the Race Judicata. Get it? Instead of Res Judicata. They're so clever, law students. Anyhow, I think it was the 30-some annual. I did run it actually when I was a student, and I hadn't run it since. So I thought, well, I'll go back out there and run it. It seems like I may have added approximately 3/4 of a minute for every year since I ran it the last time. So we might have to do some training. I might have to actually go out and run a few times before I go out and run, and we'll see what happens. 540-0580, get your legal questions answered. Frank, you're on the air.
Hello, Carl. How are you today?
Good, man. What's going on?
Oh, well, I just finished a delicious bowl of my wife's homemade vegetable soup, and I thought now would be a good time to call Carl about a question I have about a will.
Well, if you're eating vegetable soup, you're going to live forever.
What was that?
I said, well, if you're eating vegetable soup, you're probably going to live forever, so you may not need the will.
Well, I tell you what, I married a good cook. So anyhow, I'd like to have you expand a little bit and tell me a little bit what the laws are. I know of at least one, and I think maybe two cases where a person left a will to a person or a church, and they were supposed to get the interest, ongoing, but the principal never gets touched. And then somehow they break the will to get all the principal. How can then what good would a will do to set a will up like that?
Well, the will would have to flow into a trust in order to make that happen. And what I mean by that is the will would say, okay, this money goes to the church, but they can't spend it. They can only take the interest off the principal. And it would have to be in a trust situation and have to be a valid trust. And it would have to be a trust that was written ahead of time, or the will would reference a trust to be created at some later date. So breaking the trust would then be a problem with the trust, or the trust itself may have provisions in it which allow for what we call the corpus, which is what, when you said principal, in a trust we call the original body or the principal to be the corpus of the trust, to be invaded under certain circumstances. So it may be possible that a court ruled that the trust under its own terms allows for that, or the trustee found that to be the case.
Okay, now if you don't have a trust, if you just have a simple will and put that in there, that
you can't do that in a simple will per se, because the will's got to go ahead and get rid of everything ultimately.
Okay, so this would have been done through a trust.
Yeah, and it's not unusual to have a simple will that references, and I want all my assets left to my trust, or I want certain percentage of them to fund the family trust, or the trust to the benefit of the Church of Carl, or whatever it might be.
Well, I don't think this individual would have wanted exceptions or anything. He just didn't want anybody to have his money, but he let the interest go to the church, and that, now the will was broken. So what good was the will then? Well,
and it depends on how the will was written. It may have been that the clause in the will was what we call precatory, meaning non-binding, because a will couldn't specify that. So that may be why the will was, quote, in your mind, broken, is the will wasn't written correctly.
Okay. All right. So the correct way to do that would be to go through a trust.
Right. And you could put the money in the trust during your life, and then you could have it as a revocable trust that becomes an irrevocable trust upon death. But if you're trying to defeat nursing homes and other things like that, then you may not want to use a revocable trust vehicle, but then you'd give up control of the assets, and we can go downhill from there.
But then this is, you hear of this thing frequently, or?
No, I mean, people using trusts sometimes. But in terms of wills being broken, no. But it does happen, particularly if people write their own wills.
Uh-huh.
That's where we see the biggest problems.
Yeah. I don't know the details. I just know what I just told you, So maybe it was something that wasn't written right or something.
That's quite possible. I've seen some wills written, homemade wills written, where the problem is people tend to think in terms of the moment. Uh-huh. So when they write their own will, they'll say things like, I want the lawnmower repair shop bill paid, and I want some money set aside for mother's haircuts, and I want the grandkids to get the house. And these are all examples actually taken from a real will that we worked on. Well, the problem with that is, of course, who knows what lawnmower shop he's talking about. His mom's like 85, so she's probably going to predecease him anyhow. But I guess that's a nice thought to put in the haircuts. But then the grandkids, who are the grandkids? Because he'd been unmarried but living with a woman for like 30 years, and she had 2 grandkids and he had 2 grandkids. But under the law, because they weren't married, they weren't. 2 of the kids weren't grandkids.
Uh-huh.
So you can see the problems that develop.
Yeah, okay. I knew you could shed a little light on it for me, so thank you very much, Carl, and keep your powder dry.
I will try, Frank. Thank you. 540-0580, Carl Rominger answering your question. Stephanie, I know you're on a time constraint, so what's going on?
I am separated from my husband. We were married for 5 years. Before we were married, I moved into his home that he owned outright.
Mm-hmm.
I was never on the deed. I was never on the mortgages or anything like that. And I didn't know if there is any, through the divorce, if I am entitled to any of the marital property. We have 2 children. Yeah,
here's how this works. If I have a house that's worth $100,000 and I owe $50,000 on it, okay?
Mm-hmm.
And we get married that same day and you move in.
Mm-hmm.
As of that moment, the equity in the house, that original $50,000 in equity, because that's worth $100 and I owe $50, that first $50 is mine because I brought it to the marriage, okay? It's premarital property. So when we eventually cash that house out, I'm going to get the first $50, but the increase in the asset value through the course of the marriage is marital property. So let's say we're married for 10 years and we pay down the mortgage, and in the meantime, we're lucky and the price of real estate almost doubles. So we'll say the house is now worth $150 and we owe nothing on it. When we go to get divorced, I would say, well, it's mine. And you would say, well, yeah, technically, Carl, that's true, but you just get the first 50 because that's the basis of what the value was when you brought it to the marriage, the $100,000 less the 50 owed on it. But the marriage has paid down the mortgage to the tune of $50,000 for the last 10 years, and the market has increased the value of the asset over time. And so I'm entitled to the increase in the equity in that asset over that period of time. So, dear Carl, you have to split $100,000 with me, even though you get the first 50.
So if there's no, when the house was purchased and it was bought outright,
right?
Like there was not a mortgage.
So then it's
and
only
the house is worth there wasn't. There's not a mortgage on it.
So what you would have to do is 2 appraisals, a historical appraisal and a current appraisal. And the portion you'd be entitled to is the increase in value, okay?
Okay. Now,
let me go one step farther, though, because here's the next rub. Okay, let's assume the house was worth $200,000 and it's still worth $200,000. Mm-hmm. So there's nothing for you there, right? But when the judge gives that house back to husband and says that's premarital property, in considering how to divide up the other marital property, the judge may consider what non-marital property is available to each party. So let's assume that's the only non-marital property, right? And it goes to him for the tune of $200,000, and collectively you guys have another $50,000 in assets, in retirements and things like that.
Okay.
The judge might go, well, I'm not going to split that 50 down the middle because Stephanie doesn't get anything. What I'm going to do instead, instead of giving her 25 and him 25, so he's got 200 non-marital and 25 marital, and she has 25 marital, I'm going to give her the whole 50. Because now you are going to have 200,000 and she's going to have 50,000, and that's just going to be pretty close to fair. So that's the second overlay, which is even if there isn't a lot of marital value, it goes in the non-marital pot, and the court considers the non-marital pot as one of the factors on how to divide up the marital pot.
Okay. So even without a prenuptial agreement, it's not. I just always heard that it doesn't matter once you're married. That it's everything is.
Here's what happens with the house. If the house had been donated clearly to the marriage by titling both of you on it, then it would have become 100% marital property, although the court could still consider the value the husband brought in on the front end for purposes of later equitable distribution, okay?
So because I was never put on the deed...
You have a lesser claim. You have a lesser claim.
Wow. Okay.
Yeah. On the other hand, like I say, if it's the only asset of the marriage, then you might have a problem. But if there's retirements or other potentially reachable assets, then you could use it as leverage to your advantage. I got to go to break, Steph.
Okay. Thank you.
Bye.
Bye.
Welcome back. Carl Rominger here, answering your legal questions. 540-0580. Chris, you're on the air.
Carl, good afternoon. Carl, it's a pretty simple question. I saw an article in the paper the other day in the Patriot News. Somebody was ticketed for DUI. They were .27, which was above the legal limit of .08. And when I read that, I wonder if you have a beer or two and then you have a reading of .07, does that mean you are totally legal, or do you come under the heading of driving impaired? I mean, how does that work?
Okay, well, under the old law, pre-2004, and that's why I'm going to illustrate with this, if you were below a .05, you were presumptively sober.
Right.
And if you were above a .01 or .10, you were guilty, okay?
Yeah.
And then there's a secondary charge called general impairment, where the idea is that alcohol has impaired you to some level sufficient to, in the officer's opinion, imagine that, right? Very subjective, render you incapable of safe driving, okay?
Right.
And it's it's a subjective standard. But what you had was, if you blew a .05 or lower, the ability to say, yeah, but there's a presumption that I'm sober, and the jury would be told that, right? So generally, anybody who blew a .05 or lower never got charged with anything.
Right.
If you were over an 05, the Commonwealth could charge you with general impairment, and they charge all DUIs with general impairment if they have above a .08 these days, okay?
So below .05,
under
the jury
the old,
would be told.
Under the old law. We don't have that in the law anymore.
Oh, so what does the law say?
So the law now says impaired to the point that, makes you incapable of or affects your ability to drive safely. So, so theoretically, you can blow a .02, right?
Right.
And the officer can say, well, I can carry blue .02, but, man, the guy's stumbling around and seems like he's out of it. Now, the problem they have there is they've got to prove it was the alcohol, right?
Right.
So most jurors will probably then, if a doctor comes in, the doctor's going to say there's no reason to believe a .02 would have affected this person's ability to drive safely. But it still means they can make marginal calls, okay? Here's the other thing that's happening. Right now, if you get pulled over and you blow a really low BAC, and the officer still thinks maybe you seem a little loopy, they're going to take you in for blood, and they're going to start looking for other substances.
I see. If you have a legal substance in your system, some kind of pain medication, but it's not impairing you, could they then subjectively say,
yes,
he's impaired?
Yes.
And if it's prescribed.
And you can have prescription medication in you, okay?
Uh-huh.
And by the way, medication, the legislature is just so kind. Medication or any amount of medication combined with alcohol or medication alone automatically puts you in the highest tier. You get treated like the worst of the worst offenders in DUI. So here's where my clients goof up. They blow a .01 because they really haven't been drinking at all, maybe 2 wines with dinner or something, And the officer says he seems a little loopy, but then they go, so are you taking anything? And the guy's like, well, yeah, I take Adderall for, whatever. Or I took a Xanax because my grandfather died 2 weeks ago and I've been having some anxiety about it. Well, you've now given the roadmap to success to the government because they're going to test you for that particular substance. They're very hesitant to run a broad screen when they don't know what to look for.
Right.
Because it costs, say, maybe $1,000, $1,500, and the lab's going to have to test for a gazillion different substances. So they're much more likely to let you go under that circumstance than they are to go fishing, because they might not find anything, and then the district attorney's office is on the hook for that money, right? And
so the wise choice would be to say, I am not on medication.
Oh, no, don't lie. The wise choice would be to say, I don't answer questions for police officers who are detaining me because I'm an American citizen. And I'm invoking my rights.
So you invoke your right to legal representation. They can't question you.
Correct, and remain silent. If you go to my Facebook page, look under videos, you can see what happened when they DUI stopped me. Cop claimed I was speeding, which is completely untrue.
I saw that a number of months back.
And
it was pretty comical.
And the answer there is I didn't have enough alcohol in me to be illegal, and maybe that's what made me so cocksure. But nonetheless, I wasn't about to answer their questions, and I don't. And they even reference on that video another stop from Susquehanna Township. Susquehanna Township loves me, by the way. Another stop where they wanted to measure my window tint, but I refused to roll the window up so they could measure the tint.
So to answer my question, when it says the legal limit, it does not mean you're off the hook.
It does not mean you're off the hook, no. And here's the other problem. The accuracy of the testing devices is still way up in the air. The government has acted for years, and judges have let them get away with it, that this is just such simple science and we can just measure the BAC. Mm-hmm. My brother's an organic chemist, so I asked him one time, I'm like, they only test the blood sample twice. I'm like, is that good, or should they test it 3 times? And he looks at me and I go, like 3 times, like, the transporter in Star Trek, as a triple backup, because that way, if there's 3, it must be really good. And my brother looks at me again and he's like, what are you talking about? I'm like, so I explain it to him again. He's like, no, 2, 3. He goes, to take a scientifically valid test of something, I would want maybe, 20, 27 runs of it. Mm-hmm. And I'm like, why is that? He's like, well, because statistically, once I have that many runs, I'll know if I'm getting a bunch of lows or a bunch of highs and what the distribution is, because then if I look at the distribution, I know whether there's some accuracy in the machine and blah, 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 blah. But what he was telling me is basically the way that he was interested in this, because he's like, that makes no sense to him, that no true scientist would use these numbers that the government generates for DUIs. So all you prospective jurors out there, next time you're sitting there and they go, yeah, well, the Department of Health approved this procedure, and the DMV, Department of Transportation, approved this procedure, they can't get your freaking driver's license right, but you'll trust them to certify a scientific test that turns out isn't even done in a mathematical method that makes any sense whatsoever. So that's the other problem. There's an attorney, Justin McShane, locally, who's overturned a couple Lebanon County blood results and Dauphin County breathalyzers, and he has a great YouTube video where he just chews on a piece of bread for a few minutes and then blows into a portable breath test, which then claims he's a .02.
On a normal piece of bread.
On just a normal piece of bread. and as he's explaining, he goes, think about this, you're a commercial truck driver, where .02 is the standard for a DUI, okay? You can't be driving your commercial truck and be above a .02. He's like, so you just pick up your bologna sandwich and you chew on it as you drive down the road. You drop your soda, and they pull you over, and you blow the portable breath test. You're going to blow above the legal limit.
So you're going to, in their opinion, you're hammered.
Right.
And all they did was have a sub.
Right.
Well, Carl, thank you very much for the information.
All right, Chris, take care.
Oh, okay, bye now.
540-0580. Robert, you have a question about wills?
Yes, sir. 2005, we wrote one. Since then, we have moved from a house to a trailer with understanding it's personal property.
Okay.
And it's all paid for, so there's a little value there. Yeah, and the other question is, since we wrote the will, we have been blessed with 6 great-grandchildren.
Okay.
I tell my wife that because there's no real property in the will, and it stops at the daughters, and then there's kids,
Does it have the magic?
Go ahead.
Does it say anything about purse stirpes in there?
Yeah, I've got it done, yeah.
Yeah, purse stirpes means it cascades down through the generation, so you should be covered there.
Okay.
My advice is we do free wills, as you may know from listening to the show.
Okay.
So if you just call the law office, ask for the free will kit, they'll send you one out or give you a link to go to.
Okay.
And with that, you can send it in, and then we'll just give you a new free will, and we'll just update everything and evaluate it. The trick to writing wills a lot of times is to write it in a way that allows for change and flexibility, but still ends up directing the resources where you want them to go. So when I was busting on people writing their own wills earlier, they'll write their own will and say, I leave my 1998 Ford F-150 to my son.
Okay.
2 years later, they buy a 2000 Ford F-150 and upgrade a little bit,
Right.
Well, the will said the 1998, and if it said 1998, it doesn't talk about the 2000, so the 2000 falls into what we call the residual clause.
Right.
So instead, we like to say, whatever car I'm driving at the time of my death goes to my son. Or something more nebulous like that.
Okay.
All right, my friend.
Okay, I appreciate it, sir.
No problem. I got to tell you guys, Harrisburg Beer and Cigar has a CAO La Travita wrap-up tour coming. Rick Rodriguez is coming on April 20th from 3 to 7 p.m. And I don't know if you've been there or not. I was over, bought some beer there and some cigars not too long ago, and they're actually going to be a sponsor here at the show now, so you'll be hearing more about them as we go. But they have an amazing selection of cigars. And at this event, they have a purchase any 6 CAO cigars and get a ticket good for 2 free limited edition CAO cigars from Rick Rodriguez. And you purchase a box, you get a La Travita cutter, 20% off the box, and a VIP ticket good for 1 6-pack limited edition. They'll have drinks, snacks, T-shirts, raffles, prizes, and lots of swag from CAO. It's all at Harrisburg Beer and Cigar at 3842 Union Deposit Road, Harrisburg, PA. If you want to call over there to get more information, it's 541-1341. Just tell them Carl sent you. And they were kind enough, if you look at my Facebook page, I'm drinking a Double Bock by Sam Adams. And then earlier today with my lunch, I had a Yingling Bock beer. The guys over there at CAO sent me over a case of each to sample and report back. I'm a big IPA drinker, so, I wasn't sure how I'd feel about it, the Bock beers. I like both of them. The Sam Adams is a little stronger. It's a 9%er, so I wouldn't recommend just hammering those down. Whereas the Yingling is, as anytime Yingling makes a dark beer, I really like it. And again, it doesn't disappoint. And it's much more of a, drink it with your lunch, have a light beer. And of course, you may know this or not know this. I never drink at lunch during the week because I have to go back to work. But on Saturdays, I don't really consider this radio show work. So I make an exception. 540-0580. See you guys after the break. All right, welcome back. Okay, what's this going on with Tiger Woods? Now, let's talk about the game of golf for a minute. First of all, I'm really annoying to play with because I actually pay attention to the rules. And when we play USGA, and I got the book, and I've actually looked up rulings before to cause you grief. On the other hand, it makes for a fair game. But as you may realize, as I said there, a viewer called in, some television viewer anywhere. So when you're playing golf, you've got the rules officials that are on the course, you got the other players, the caddies keeping an eye on you, and if it's the Masters or some other big thing, you have a million eyeballs at any given moment trying to figure out what you did wrong. So good old Tiger, gets this drop wrong. Somebody calls it in, they figure it out, and of course they can disqualify him, or they can keep him. Well, let's talk about this. Does anybody out there believe that they thought seriously about disqualifying Tiger Woods from the Masters? How does the Masters make money? Well, sponsors pay money to the television station to air it. And the television station pays big bucks to the boys in Augusta, and I guess maybe some girls now too, to allow them to air that. And so you cut Tiger out, and the ratings will fall. What do you guys think, 20%, 30%? I mean, it's still the Masters. It's huge. But if Tiger's not in it, a lot of people are just going to turn the TV off, I think. Of course, Tiger Woods isn't quite the commodity he was at one time, but he's also a favorite to win it at one point. So who knows what's going to happen? But I'm just saying, I find that to be completely funny. Oh, yeah, they were thinking about disqualifying Tiger Woods from the Masters. Really? Don't lie to me. Linda, you're on WHP 580.
Hi.
Yeah.
I have a question about a custody case.
Yep.
The father has primary care, and the mother wants to get him back. How difficult is that, and how long does it take? It's a long story.
Well, I was just going to say, it's kind of like asking me, how long is it going to take to rewire my house?
Yeah.
And the answer is, I don't know. It depends what kind of wiring you got in there already, how we can get into the walls, and whether the last guy was smart enough to keep some fish snaked through the conduit if there happens to be any.
Uh-huh.
You know, occasionally you get an electrician that doesn't leave a fish behind. So what can you do? Uh-huh. But here's my point. My point is, I would have to know a lot more. But generally speaking, we'd have to figure out why the court went that way in the first instance.
Oh, okay, real quick, brief. She left him.
Right.
And he went up and had her fired from her job, threatened to kill her, and had her fired. And then he wouldn't give her the kids. And then he left her have the kids one day, and the second she had him, he went and got a special relief thing and got primary care. She didn't have no income or no place to stay, so she kind of agreed with it. And then there's a lot of stories.
So the answer is, here's the dealio. The law wants the kids to be equally split between the parents at the end of the day, and I know a bunch of people out there like, Carl, you know the courts are biased, blah, blah, blah. But the general answer is, if both parents are fit and they both live within the core community of the children, which would be, if somebody wants to move from Lebanon to Cumberland County, that may create a problem, okay?
Yeah.
But let's assume everybody's within 10 miles of the school the kids go to. There's no reason why you can't get back to 50-50 if nothing else.
There's a lot of issues behind his story. And then they moved in together, boyfriend and girlfriend, 4 of them, to watch the kids. And then he left her have the kids.
Right.
And then one day he tried, and everything was going, verbally, how they agreed. And then he tried to switch the kid to a different school. And then, the process started that she wants to get him back. He lives with 5 other adults, and, went in tried to get him back, and then the judge was upset and said it has to be upheld how it was.
Right.
For now, until, and then you have to go to a conference.
Well, yeah. Okay, so, the first thing is there's no imminent danger to the child, so the judge maintains the status quo. Now they're going to try to conciliate or mediate it, and then ultimately, if they can't agree, then they'll have a full trial on the merits.
Because there is some danger to the children.
Well, it depends if the judge was presented with enough information. I mean, danger to the children.
She got to tell her side of the story. She never got killed.
Yeah. Is she represented?
Yes.
Yeah, so she should be fine then.
Does she have a good chance? The mother, going back to the mother, we have a lot of evidence.
Well, I don't know. That's what I'm trying to tell you. I don't know without knowing what the evidence is. If I have evidence that the other guy's a serial killer, I'm going to win for sure, right? Uh-huh. If my evidence is, well, Dad's a jerk, and he doesn't communicate well with me, and he only feeds the kids pizza, and clothes always come back dirty, that's probably not going to quite be like, the same as he's a serial killer.
Uh-huh.
All right?
Okay.
Good luck. 540-0580. Bill.
Hello.
Hey, what's going on?
Hey, Carl. Got a question on common law marriage. Enjoy the show, by the way, first-time caller.
Well, thank you very much.
I'm 74, and I have 2 friends about the same age. Both of them widowed when around 40, and they decided to cohabitate and have since then. Part of the reason they did it is they both receiving disabilities, so they decided not to go through with the marriage. Mm-hmm. She owns the house. He has paid the taxes for 35 years, and but they've never filed a joint tax return. It's always been individual.
Right.
What was interesting was when, and she just passed away, so the house where we lead into the question. When he won $100,000 and some odd in the lottery about 5 years ago, the lottery required her to come with him. And from what I was told, the state records indicate there was a common law marriage. What is the rule of property when two people have cohabitated?
Okay, well, here, common law marriage in Pennsylvania is a storied entity. So prior to 2004, okay, because in 2004, Ed Rendell signed legislation from the legislature that abolished prospectively common law marriage.
Okay, I read that online, but
so you can't create a common law. You cannot create a common law marriage after 2004.
Okay.
So as of January 1, 2004, if it wasn't in existence, it didn't exist. If the common law marriage would have been created previous to that, then there's an open question. So here's when it comes up. If two people are getting along happily, right, they probably aren't going to litigate the issue whether there's a common law marriage. It only comes up when one side tries to seek a divorce from the other, or somebody dies and some kids are trying to claim, that there was a marriage, for instance. Or maybe the spouse is trying to claim that there was a marriage, or that they are the spouse. Well, the law then says the person asserting common law marriage must prove by clear and convincing evidence that there was a in presente agreement to marry, not an in futuro agreement to marry. Now, come on, can we do the Latin on that one, kids, or do I have to tell you what it means?
No, you have to tell me what it means.
So, but here's the difference. Do you want to get married? Yes. Let's get married next month in the Caribbean. That's in futuro. The in presente, which occurs but is very rarely actually seen, and I'll explain when it was usually seen, is when you say, I want to be married, and she looks in your eyes and says, I want to be married too. Let's get married right now. And you say, we are married. And she says, yes, we are married. Now you've created this in present contract for marriage. Okay, now.
I'm not sure either occurred.
Well, let me stop you. Here's my point. Nobody knows if that occurred or not, because once the parties are on the outs or somebody's dead, one side's asserting that there was no marriage and the other side's asserting there was a marriage. So the court says, how the heck are we going to figure this out? Well, what we're going to do is we're going to look at the actions of the parties. Did they cohabitate?
Yes.
Did they file joint tax returns? That's one of the methods.
Yes, no.
When they signed the Christmas cards, did they sign it Grandma and Grandpa Bill?
Yes.
Or did they sign it separately?
No, they referred themselves with the grandchildren as Grandpa and Grandpa.
So you collect all this evidence, and then you have a good old-fashioned hearing on whether or not they were married.
Okay.
Now, there is an old rule that says that a common law marriage can never arise out of a meretricious relationship, which means if I'm married and I'm catting around with some girl, and then I'm cohabitating with her, and then I divorce my other wife, and now we're going to claim to be in a common law marriage later. There is an old case that says because the origination of the common law marriage was of a meretricious relationship, a bad affair type thing, we're not going to ever give it common law status.
Okay.
But I don't see that case uniformly applied, and I tried to apply it one time, and the judge seemed to think I was cuckoo, because that's kind of an old concept, not so much of a... Every time I quote something from the 1800s, the judges seem to get mad at me.
Yeah, one thing I'm aware of, because we went to the wedding when their son got married, the wedding invitation referred to Andy and Louise as the parents of the groom.
Oh, well, yeah, those are the kinds of... That's gold for that kind of hearing.
That's a goal, okay.
That's gold. All right, my friend, hope that it helps you out a little bit.
Thank you very much. Appreciate it.
All right, take care.
Bye-bye.
540-0580. See you guys after the break. Welcome back. Carl Rominger here, answering some, maybe all, pieces of your legal questions. 540-0580. Chris, you're on the air. Chris.
Hey, Carl.
What's going on, brother?
Hey, I got a property rights question for you, and if I understand correctly from something I saw on GAL, you're familiar with these.
Okay.
My property is a little bit unique. We purchased it just shy of 3 years ago, and when you come in our driveway, you come off of a street that the house itself is not on. So the house sits on one street, and then we're real close to the corner. So the property is almost like an L shape, and the driveway comes in off of another street. When we bought the property was kind of not taken care of for years, and so the neighbors to the left and right of my driveway had been mowing my lawn.
Okay.
And so when we moved in, I communicated with both of them and basically just said, hey, do you want me to start mowing that lawn again? I'm more than willing to, but in the same sense, the way that it's laid out, the lawn short of my driveway coming up through there kind of looks like it's part of their property. So they both communicated they just prefer to mow it because it makes their property look bigger. And then, one side of the driveway there's only 6 feet, so to have the 6-foot strip unmowed, and the other side of the driveway there's maybe 12 feet. But again, to have those strips mowed at different times, it just doesn't look as clean.
Right.
I guess my question to you is how fearful should I be about losing that property down the road because they claim they've maintained it?
Oh, well, the short answer is maintaining it alone could create adverse possession, but not if they do it with your consent and permission. So usually what I would do is recommend you go to them and say, I have no problem with you continuing to do the lawn care and maintenance, but I want you to sign this little document here.
Right.
That acknowledges that you're doing it with my permission.
Right. Well, last year, the gentleman on the one side of the driveway, he started to let his property fall apart. In fact, it sounds like his property is about to go into foreclosure. So I started mowing it because I didn't want to look at that when I came up the driveway.
Right.
So I started mowing my portion. The gentleman on the other side of the driveway, it's a little wider. Like I said, it might be 6 feet at one end, but frankly, until it gets up towards the top, it might be closer to, I don't know, maybe even 20 feet. But one thought I had is if I put some planter boxes in there on the soil and we maintain the flowers, but he continues to mow, does that still show that I own the property, correct?
Yeah, but then he's still mowing it for some reason, and I'm not thinking he's going to cause him to win it, but I'm a little concerned about it. Why wouldn't he want to just sign a piece of paper?
What's that?
Why wouldn't the guy want to just sign a piece of paper?
Well, I don't know.
Carl, I don't want to really confront him with it. I understand that.
One thought we have about that property is it's a piece of our property, and it's not a huge property. I mean, it's just shy of an acre.
Right.
And so, one thing my wife and I have always said, it's a shame because that property out on that side there, there's very little we can do with it. So, we thought about putting some planters in, just 4x8 planters, and I don't know if we'll kind of like raised beds, whether we'll put flowers in it or put some gardening stuff in it. But still, then we could use the property a little more. Right.
Put tomatoes and basil in there.
Exactly.
And actually, if you grow some hot peppers too, they'll put good color. And so if you're looking for something that's edible and ornamental, that works pretty well too. But
again, I guess my question is, if we do that, I mean, that does show that it does show our desire for it to be our property, right? I mean, you would have a harder argument.
It's correct, but he's still mowing it, so maybe up to the edge where he mows it then.
Right.
But I'm just saying, this is a very simple solution. You write a short agreement that just says, my name is Ed, your name is Bill. I'm giving you permission, Bill, to continue to do lawn care because it's the most aesthetic way to do things and seems to make sense. But you acknowledge that you're mowing my grass.
Right.
And you both sign it. You could record it at the courthouse to be extra tricky and reference your deed in it. But you wouldn't need to do that because then later, if he just brought an action against you, you would have it to say, no. He knew that because adverse means it has to be done without your permission. So the easiest way to kill adverse possession, okay? The easiest way to kill it is to give permission.
Right.
Then you don't even have to enforce anything.
Right.
I give you permission to do whatever you want to my property.
Right.
I give you permission, to build a building on my property, whatever. The point is, at that point, they can't gain any title over it.
Right.
So instead of getting willy-nilly about it, and if the other guy has no ill intent, why wouldn't he sign it?
Well, and I think he would. I figured it's.
It's not like asking. It's not like you're asking your wife for. It's not like you're asking your wife for a prenuptial here. It shouldn't be that scary.
Right.
All right.
All right. Hey, thanks, Carl.
All right, boss. 540-0580. Gene, you're on the air.
Hi. I was let go from a job in a public place.
Okay.
And and I'm getting unemployment, but I got a letter in the mail that said that I can't come on the property or I'll be arrested for trespassing, and if I contact other employees, I'll be arrested for harassment. Can they do that?
Well, they can certainly keep you off the property, right? It's private property.
Well, it's public. It's a public place.
When you say public place, do you mean the Walmart or do you mean a government building?
I mean like a nursing home.
That's not a public place.
It's not.
That's a
but
private...
Anybody can come and go. I mean, it's open to the public.
But no. It's only open to the portions of the public the owner wants to admit. Okay? Harrisburg Mall can write you a letter that says you're not welcome to come into the Harrisburg Mall.
Okay.
You got it?
Yeah.
Okay, then the mall's a public place and people come and go, but the mall says you can't.
Okay.
Okay? So yes, they can do that. As for contacting their employees, that's a trickier one. Because maybe the employees want you to contact them, right?
Uh-huh.
If that's the case, then I don't think they can regulate it. But if the employee doesn't want to be contacted, or you try to contact them at work, then that will be a problem.
Okay, then I could be arrested for going on the property.
You could go to jail.
Oh. So something, okay.
Now listen, I know you're not liking the answer, but liking the answer and the answer being wrong are two different things.
Okay.
And I am telling you this.
All right.
You
the
will
letter
be...
didn't come certified. It just came regular mail, but...
Right. Well, that doesn't make a difference.
Okay. But I got the letter, and I didn't think they had a right to keep me off of a public place.
Listen, if they wrote you a letter and said, you can't come here because you're black, they'd be in trouble, okay?
Okay.
If they wrote you a letter and said, you can't come here because your name is Bob Durgan and you wear a cowboy hat, that would be perfectly legal.
They didn't give a reason.
Now, they don't even have to give I'm saying they can't use a reason that's impermissible, okay?
Okay.
So the best way to write the letter is just say, Dear Gene, stay the hell away, period.
Okay.
And then if you show up, it'll be called defiant trespass. It's a misdemeanor, and the police may take you into custody, and you could do up to a year in jail.
Okay.
Do not go there.
Okay, you answered my question.
All right, bye. Harry, you're on WHP 580. Harry.
Hello?
Hey, Harry, what's going on?
Yeah, I have a question on rental landlord issue.
You're going to have to hold till after the break. Call me back in 6 minutes. 540-0580. I'll be back in a few minutes, kids. In the meantime, go to RomingerLaw.com or look me up on Facebook to see all the fun photos of the studio here.